Credible Threat Audio.
Credible Threat presents They Really Said That. This week's episode, A Fear of Too Much Justice.
This is Dora Worthy.
And Bill McKinley.
And we're here on April 22nd, 1987, waiting outside the United States Supreme Court for their decision in the landmark case McCleskey v. Kemp. Bill, what are the issues in this case, McCleskey v. Kemp, which has reached the Supreme Court here in 1987?
Warren McCleskey, an African-American, was convicted of 2 counts of armed robbery and 1 count of murder in Fulton County, Georgia. Now, McCleskey was given the death sentence, but in an appeal, McCleskey's lawyers argued that the death sentence in Georgia was administered in a racially discriminatory manner.
Did they give any evidence?
They submitted a study by Professor David Baldus of the University of Iowa College of Law. The Baldus study examined 2,500 murder cases in Georgia. The study found that African Americans, like McCleskey, convicted of murdering white victims, were 4 times more likely to be given the death sentence than whites convicted of murdering African American victims.
Did the study look at other factors?
Yes, they adjusted for 39 other non-race variables and still concluded that African Americans were 4 times more likely to be given the death sentence for similar convictions. This would make Georgia's pattern of death sentences a violation of the 14th Amendment to the Constitution, which guarantees equal protection under the law.
For comment, we have with us Diane Russ Tierney, a lawyer who will go on to become director of the Capital Punishment Project of the American Civil Liberties Union. Ms. Russ Tierney, what do you think about the McCleskey v. Kemp case?
If the justices live in the world, they will see the pattern of racially biased sentencing for what it is. The Supreme Court had been presented with the most sophisticated and comprehensive study of racial bias in capital sentencing that had ever been conducted.
Well, it seems as though those facts would speak for themselves.
We'll see, Dora.
What's that noise, Bill?
I think the decision is being announced. We're hearing from the Supreme Court justices now.
The criminal defendant alleging equal protection violation has the burden of proving existence of purposeful discrimination.
Purposeful discrimination?
Yes, the prosecutors and judges would have to say out loud that they were discriminating.
At most, the Baldus study indicates a discrepancy that appears to correlate with race.
Apparent disparities in sentencing are an inevitable part of our criminal justice system.
So the facts don't speak for themselves?
Apparently not.
McCleskey's claim, taken to its logical conclusion, throws into serious question the principles that underlie our entire criminal justice system. If we accepted McCleskey's claim that racial bias has impermissibly tainted the capital sentencing decision, we could soon be faced with similar claims as to other types of penalty. The United States Supreme Court therefore affirms the decision of the lower courts, and the death sentence will stand.
Did any of the judges dissent?
Yes, 4 out of the 9 justices voted against the decision, including Justice Brennan, who said,
"The court states that its decision is based in part on the fear that recognition of McCleskey's claim would open the door to widespread challenges to all aspects of criminal sentencing. Taken on its face, such a statement seems to suggest a fear of too much justice."
Diane Russ Tierney, any comment?
Evidently, the justices do not live in the world.
Well, Bill, the Supreme Court seems to have decided that discrimination only exists if the perpetrator says it out loud.
That's right, Dora. And as we heard in the last episode from H.R. Haldeman and John Ehrlichman, the strategy for the last several decades has been to find ways to discriminate without saying it out loud.
Is this Supreme Court decision an isolated incident?
Well, in 1995, in the case of Armstrong versus the U.S., the petitioners were claiming that prosecutors were choosing to charge and prosecute non-whites more often for similar crimes. They wanted to examine evidence from prosecutors' files, but the Supreme Court ruled that they could not examine prosecutors' files for evidence of discrimination unless they first provided evidence of discrimination.
But wouldn't they need to look in those prosecutors' files to find that evidence?
That's right. So, in essence, the Supreme Court made prosecutors safe from charges of racial bias.
Unless the prosecutors say out loud that they intend to discriminate.
That's right. And in the case of Perquette versus Elm in 1995, the Supreme Court ruled that prosecutors don't even need to provide good reasons for their choices.
Unless a discriminatory intent is inherent in the prosecutor's explanation, the reason offered will be deemed race neutral.
This process does not demand an explanation that is persuasive or even plausible.
Not even plausible?
They really said that, Dora. And in 2001, in the Alexander versus Sandoval case, the Supreme Court ruled that
There is no private right of action to enforce disparate impact regulations promulgated under Title VI.
What does that mean?
that people can't bring lawsuits about racial discrimination against government bodies.
The law prohibits only intentional discrimination.
Which means that if no one says it out loud, the facts do not speak for themselves.
That's right.
And what's the result of this, Bill?
Well, by 2014,
27 years from today.
African Americans will be only about 13% of regular drug users, but they will be 35% of those arrested, 55% of those convicted, and 74% of those sent to prison for drug possession.
And those facts still won't speak for themselves?
Not according to the United States Supreme Court, Dora.
You've been listening to A Fear of Too Much Justice, a presentation of Credible Threat Audio. They really said that. All quotes by public officials are from public sources. They really said those things. A Fear of Too Much Justice was written by Edward Mast, directed by Robert Lee, with the voices of Meg Savlov, Rich Hawkins, Vince Balestri, David Baum, Edward Mast, and Jessica Severance. For more Credible Threat Audio, go to crediblethreatworks.org. Credible Threat 2014.